Hello and welcome back to another episode of Courts This Week, your go-to source for the latest legal updates presented by Livelaw. I'm your host, Ostika Das, and I'm here to take you through the most significant updates from this week. From the corridors of the Supreme Court to local judicial proceedings, I'll be providing you with clear and concise summaries that keep you informed and ahead of the curve. Remember, for a more in-depth understanding, do visit our website at www.livelaw.in. In today's episode, we are going to talk about Delhi Chief Minister Arvind Kejriwal's release on interim bail, plea over bomb threats in Delhi schools, the framing of sexual harassment charges against BJP MP and former Wrestling Federation of India Chief Brij Bhushan Singh, and much more. So let's dive into the headlines. This week's most significant development comes from the Supreme Court, which granted interim bail to Delhi Chief Minister Arvind Kejriwal, who was arrested by the ED in March in connection with the Delhi liquor policy case. Kejriwal, head of the Aam Aadmi Party and a prominent figure in the ongoing Lok Sabha elections, has been released on interim bail until June 1st. The court's decision follows Kejriwal's plea challenging his arrest after both the trial court and the Delhi High Court rejected his appeals. During last week's hearing, the bench comprising Justices Sanjeev Khanna and Dipankar Datta considered Kejriwal's eligibility for interim bail, especially in light of the elections. Despite opposition from the Solicitor General and Additional Solicitor General, who argued against bail based on evidence presented by the ED, the bench acknowledged Kejriwal's status as an elected chief minister and the exceptional circumstances of election time. It noted that the liquor policy case was registered back in August 2022 and Kejriwal was only arrested in March 2024 after nearly 1.5 years. The bench also observed that it was dealing with the case of an elected chief minister, not a habitual offender, and the general elections take place only once in 5 years. The bench also orally suggested that if interim release was directed, Kejriwal would not be allowed to perform official duties, as that would have a cascading effect. This week, true to its words, the court imposed several conditions while granting interim bail, including restrictions on Kejriwal's official duties and interactions related to the case, namely that Kejriwal shall not visit the office of the Chief Minister and the Delhi Secretariat, that he will not make any comment with regard to his role in the present case, and that he will not interact with any of the witnesses. Next, we turn to a short update regarding the Supreme Court disposing of former Jharkhand Chief Minister Hemant Soren's plea challenging his arrest by the Enforcement Directorate, deeming it infructuous following the Jharkhand High Court's dismissal of a similar petition. Soren's plea was taken up by the Supreme Court on 29th April, but by 3rd May, the High Court had already ruled against his challenge to the ED arrest. Consequently, Soren lodged a fresh special leave petition contesting the High Court's decision. This week, a bench comprising Justices Sanjeev Khanna and Dipankar Datta stated that the initial petition had become moot in light of the High Court's verdict. However, they affirmed Soren's right to present all arguments in his upcoming SLP, scheduled for hearing this coming week. Amidst the ongoing general elections, tensions are running high across the country as political parties fiercely contest seats and vie for power. With each phase of polling, the nation is gripped by anticipation and speculation over electoral outcomes. Against the backdrop of this charged atmosphere, in a very important development this week, the Association for Democratic Reforms has moved an application in the Supreme Court urging the Election Commission of India to promptly publish the exact number of votes cast in elections. ADR highlights that during the current Lok Sabha elections, the ECI has been delayed in releasing voter turnout data for various phases, with discrepancies observed between initial and final figures. For instance, data for the first phase of polling was published after 11 days, while for the second phase it took 4 days. Additionally, there was a notable variation of over 5% in the final voter turnout data compared to the initial release. ADR argues that this delay and the lack of transparency have caused concerns among voters, undermining confidence in the electoral process. To restore faith in the system, ADR seeks a court directive for the ECI to promptly disclose scanned copies of the account of votes recorded within 48 hours of polling closure, ensuring transparency and accountability. This week, the Supreme Court delivered its verdict on a plea by Aam Aadmi Party MLA Amanatullah Khan against the Delhi Police's decision to label him a bad character by opening a history sheet against him. During the hearing, the Supreme Court had also initiated a suo motu case against mechanical entries in history sheets against innocent individuals hailing from socially, economically, and educationally disadvantaged backgrounds. Through this judgment, the Supreme Court has now modified the Delhi High Court's decision, ruling that details of Khan's minor school-going children and his wife, with no adverse material against them, should not be included in the history sheet. The Delhi police had disclosed such details despite a lack of evidence against them, and the information had been widely publicized. The court emphasized the need for police officers to exercise caution to prevent the disclosure of minor children's identities as provided by law. For more context, a history sheet is an internal police document used to record an individual's past involvement in crime, aiding in understanding patterns of behavior and facilitating future investigations. Justices Surya Kant and K.V. Vishwanathan clarified that this document is not publicly accessible. Further, the court directed all states and union territories to revisit their policies regarding history sheets, urging caution in recording details of innocent individuals from disadvantaged backgrounds, along with those belonging to backward communities, scheduled castes, and scheduled tribes. This week, a Supreme Court bench comprising Justices Hima Kohli and Ehsanuddin Amanullah continued hearing the contempt case against Patanjali. Last month, the state had suspended manufacturing licenses of 14 products of Patanjali and Divya Pharmacy, filing a criminal complaint against the company's managing director Acharya Balkrishna and co-founder Baba Ramdev under the Drugs and Magic Remedies Act. During this week's hearing, it was pointed out that despite the license suspensions, misleading advertisements from Patanjali were still prevalent online and on various channels. However, Patanjali's counsel assured the court that they would present a comprehensive plan to address this issue by the next hearing. Additionally, the bench issued notice on an application by Patanjali MD seeking action against alleged offending statements made by the president of the Indian Medical Association regarding the Supreme Court's observations on the need for IMA to take action on complaints of unethical practices by practitioners of modern medicine. Furthermore, the Ministry of Ayush's letter to licensing authorities regarding Ayurvedic and Ayush product ads under the drugs and cosmetic rules faced scrutiny. Through this letter, the ministry had asked state and union territory licensing authorities to not take any action against ads pertaining to Ayurvedic and Ayush products under the drugs and cosmetic rules. Multiple writ petitions challenging the rule are also pending in various high courts. After criticism from the Supreme Court, the central government said that it would withdraw the letter forthwith. In a significant development this week, a Supreme Court bench comprising Chief Justice D.Y. Chandrachud along with Justices J.B. Pardiwala and Manoj Mishra heard petitions challenging the Calcutta High Court's ruling invalidating 25,000 SSC jobs due to alleged fraud. The court modified its earlier interim protection, allowing the CBI to continue its investigation into the allegedly illegal appointments approved by the state government. However, the court specified that no coercive action should be taken during the investigation. Furthermore, the court affirmed the temporary protection granted in November 2023, which shielded the appointments for 6 months while the High Court deliberated on the issue. However, during this week's hearing, the Supreme Court clarified that individuals unlawfully appointed and retained under this protection must reimburse their entire salary from the date of the order until the final judgment. The matter has now been adjourned to 16 July for further hearing. The Supreme Court has clarified that its directive to reserve at least 1/3 of seats for women in the Supreme Court Bar Association's Executive Committee is an experimental measure subject to review. The bench of Justices Surya Kant and K.V. Vishwanathan said that any difficulty faced in implementing the reforms could be placed before the court. This observation was made after senior advocate Praveen H. Parekh, representing the lawyers' body, mentioned the matter and highlighted the upcoming general body meeting to ascertain the validity of the court's order. For more context, last week, the bench had directed the reservation of a minimum of 1/3 seats for women in the Supreme Court Bar Association's Executive Committee. It had reaffirmed that the reservation would apply to the upcoming elections, and in the ensuing elections, the treasurer's post would be reserved exclusively for women candidates. Following the court's directions, the SCBA called for an emergency meeting this week to discuss the implications of the order and determine the next steps. In its resolution, it was argued that the bar's autonomy and constitutional principles were infringed. During this week's hearing, Justice Kant's bench underscored the importance of gender representation and questioned the association's resistance, emphasizing the need to align with constitutional values. He also pointed out that a consent order had been passed, referring to a statement made by the president of the Supreme Court Bar Association welcoming this order. It also clarified that the order was on an experimental basis and the court would entertain difficulties in its implementation. Finally, it recorded that the emergency meeting that was scheduled to be held on 7th May was cancelled now. In a thought-provoking development this week, the Supreme Court highlighted concerns over the rigidity of the Medical Termination of Pregnancy Act vis-à-vis its limitations on abortions beyond 24 weeks, even in cases of minor victims of rape and incest. The court, through a bench of Chief Justice D.Y. Chandrachud and Justices J.B. Pardiwala and Manoj Mishra, was hearing a case involving a minor seeking termination of pregnancy after sexual assault. When her mother moved the Bombay High Court, the medical board gave an opinion declining termination, stating that there was no congenital abnormality. The diagnosed and gestational age of the fetus was between 27 and 28 weeks. This report, however, did not record the impact of the pregnancy on the physical and mental health of the minor girl. Initially permitting termination despite the advanced stage of pregnancy, the Supreme Court later revisited the decision upon medical advice regarding associated risks. The minor and her parents, considering potential complications, altered their stance, prompting the court to reassess the matter. Ultimately, prioritizing the minor's well-being and her preference to carry the pregnancy to term, the court revoked its earlier order. In a significant verdict this week, the Bombay High Court upheld the Maharashtra government's decision to rename Aurangabad and Osmanabad city and revenue areas. In 2022, former Chief Minister Uddhav Thackeray's Maha Vikas Aghadi government initiated the renaming, deciding to rename Aurangabad and revenue areas as Sambhajinagar and Osmanabad city and revenue areas as Dharashiv. The subsequent Shinde-Fadnavis government made a fresh decision on renaming, deciding to change Aurangabad to Chhatrapati Sambhajinagar. Last year in February, the Union Home Ministry approved the renaming. Accordingly, the state government published a draft notification on the same day, inviting objections from the general public to the renaming of the revenue areas of Aurangabad and Osmanabad in terms of Section 4 of the Maharashtra Land Revenue Code 1966, which permits the state government to alter the limits of any revenue area or abolish any such revenue area and also to name it. The renaming faced challenges from various quarters, including PILs and writ petitions. Critics argued that the decision overlooked public sentiments and violated constitutional provisions, alleging political motives and religious discord. However, the state government defended its actions, stating that the renaming honored figures respected across the state, devoid of religious connotations. This week, the Bombay High Court, through a bench comprising Chief Justice Devendra Upadhyay and Justice Arif S. Doctor, dismissed the petitions, ruling that the government's notification for renaming did not contravene the law. The renaming process, governed by the Maharashtra Land Revenue Code, saw approvals from the Union Ministry of Home Affairs after inviting objections from the public. In a move addressing the growing concern over deep fake technology, the Delhi High Court this week took notice of a public interest litigation filed by senior journalist Rajat Sharma, chairman and editor-in-chief of India TV. The PIL highlights the potential threats posed by deep fake technology, which uses sophisticated artificial intelligence to create convincingly fake audio or video content. Examples cited include fabricated videos of Bollywood actor Amir Khan endorsing a political party and Congress leader Rahul Gandhi purportedly being sworn in as Prime Minister. Sharma's plea emphasizes the dangers of deepfakes, including misinformation campaigns and identity theft. The PIL urges the union government to identify and restrict access to applications, softwares, platforms and websites facilitating the creation of deepfakes. In response, the division bench of the Delhi High Court, comprising Acting Chief Justice Manmohan and Justice Manmeet Pritam Singh Arora, acknowledged the severity of the issue and sought the government's stance on addressing it. The court has requested a response from the union government through the Ministry of Electronics and Information Technology. Last week on 1st May, in a shocking incident, approximately 100 schools in Delhi and the National Capital Region received bomb threat emails prompting immediate evacuation of students, teachers and staff and the closure of the schools. Despite extensive investigations by bomb squads and Delhi police, no suspicious items were found, leading authorities to deem the threats as hoaxes. Subsequently, Advocate Arpit Vargava filed a plea seeking a comprehensive action plan to address such threats and ensure the safety of children, teachers and staff in Delhi schools. During the hearing of this petition this week, the Delhi government's counsel informed the court that the Delhi police has a standard operating procedure to handle both hoax and genuine bomb threats. It would be difficult to deploy police personnel to all schools in Delhi, considering that there were around 5,500 schools in the national capital, the counsel admitted. However, he explained that as per the SOP, once a bomb threat is received, the first step is for the school to inform the police and the second step is evacuation. The court was further informed that mock drills are taking place in schools regularly and that every school has an evacuation plan. However, the bench of Justice Subramaniam Prasad expressed concerns about the general nature of this SOP. He further requested details from the Delhi government and the Delhi police on the nodal officers responsible in cases of bomb threats, the number of mock drills conducted in schools, and the timeline for responding to threats. The matter is scheduled for further hearing on 16th May. This week, a Delhi court has formally charged Bharatiya Janata Party MP and former Wrestling Federation of India President Brij Bhushan Sharan Singh with sexual harassment allegations involving 5 women wrestlers. The charges stem from incidents reported to have taken place between 2016 and 2019, spanning locations such as the WFI office, Singh's official residence, and overseas. Additional Chief Metropolitan Magistrate Priyanka Rajput of Rouse Avenue Courts reviewed the evidence and deemed it sufficient to frame charges against Singh for outraging the modesty of women and sexual harassment. Last month, Singh's request for further investigation and additional submissions regarding the charges was denied. Currently, Singh is out on bail in this case along with co-accused Vinod Tomar. And that's a wrap for this week's Legal News Roundup. But before we bid adieu, the entire livelaw team has a small request for our dedicated viewers. As an independent and fact-driven media organization, we are deeply committed to fearless and ethical journalism. To continue bringing you the latest legal updates, especially in this dynamic audio-visual format, we rely on your support. So here's a fantastic 6 for you. Give our video a thumbs up if you found it informative. Share it with your family, friends, classmates, and colleagues to spread the knowledge. Make sure you subscribe to our YouTube channel for more insightful content. Drop your valuable thoughts and feedback in the comments below. We love hearing from you. Don't forget to tap that bell icon to stay updated with our latest releases. And lastly, make a quick visit to our website at www.livelaw.in for our in-depth reports and analysis. I'm your host, Ostika Das, and it's been a pleasure bringing you this week's legal updates. Until next time, stay informed, stay engaged, and stay tuned to Live Law. Thank you for watching.